All right, I will call the Senate Judiciary to order. Would the Secretary please take the roll?
Senator Harris. Here. Senator Dondero Loop. Here. Senator Orenshaw. Here. Senator Wynn. Senator Hansen. Here. Senator Krasner. Here. Senator Stone. Here. Chair Scheibel.
Here, and please mark those senators present who are not yet present when they are here, as they're all on their way. So today we have one bill hearing on our schedule. It's SB 223. I also understand we're having some technical difficulties. So just to give you all the lay of the land, Senator Harris will be presenting this bill along with two individuals, Mr. Buckley and Ms. Warren Kay. I understand that Ms. Warren Kay is with us via Zoom or some other kind of video application. I also understand, as is Mr. Buckley, I also understand that we are not able to connect via video with the Grant Sawyer building the way that we normally are. So this meeting is still being broadcast in Grant Sawyer, but anybody who is in Grant Sawyer can see us. We can't see them. If there's anybody in Grant Sawyer to testify, which is a question we're still trying to get answered, they will still be able to participate by calling in and giving testimony over the phone. So just in case there is anybody down in Grant Sawyer right now, I'm going to read that phone number. It should be available to you down there, but just, to make sure that everybody gets to participate today, the phone number to call to give testimony is 888-475-4499. And our meeting ID number is 859-540-95100. So I think at least for the first portion, for the presentation and the questions, we shouldn't have any problems. This will be like old times, having presenters via Zoom, and we'll ask our questions as usual. And then when we get to testimony and support and opposition and neutral, we'll just have to be a little bit flexible to make sure everybody gets to participate. And with that, I will open up the hearing on SB 223 and turn it over to Vice Chair Harris.
Thank you so much, Chair Scheibel and members of the Senate Judiciary Committee. My name is Dallas Harris. I represent District 11, and I'm here to present Senate Bill 223 to you all today. This is a bill brought by the property law section of the Nevada Bar, and so I am going to turn it over to the experts in this area, Ms. Warren Kay and Mr. Buckley, to walk the committee through the bill, and then we will be open for any questions if the committee has them.
Thank you so much, Vice Chair Harris. Mackenzie Warren Kay with McDonald Carano on behalf of the real property section of the Nevada State Bar. Thank you, Senator, for allowing the real property section to bring this bill forward. I want to direct members to Nellis. We have posted a memo of SB 223 that includes a chart that breaks down the bill section by section, because it does touch on quite a bit. And this bill is highly technical. Just a brief background, the State Bar has various practice groups. They are the attorneys from around the state that interface with NRS in these specific practice groups. With respect to the real property section, SB 223 is really an omnibus bill doing several things. Sometimes it's just rearranging NRS, moving things to different chapters, or perhaps they make more sense. So there is no substantive change. Other sections that Mr. Buckley will touch on just give clarity. Some remove outdated provisions, things that might not even exist, but each of the amendments have a common goal to provide predictability in the law for our real estate attorneys as they're interfacing with these various laws. And with that, I will turn it over to Michael Buckley, who is the section chair of the real property group.
Thank you, Mackenzie. Madam Chair, also Madam Vice Chair, thank you very much for allowing us to bring this bill. I think Mackenzie explained it quite well. We deal with these statutes all the time, and every once in a while we encounter sections that need tweaking. They don't, need clarity in many cases. I think I've divided our suggestions, basically 6 provisions, and I'll go through them in general, and I can point out exactly the pages if you're interested. But the first change is in sections 1 to 4, and this deals with where you record a notice of a lis pendens, or that a notice that a lawsuit's been filed affecting real estate. And the existing language is, it says where the property or some part is located. So we want to change that to where the property or any part, so that wherever the property is, that county has record of the lawsuit. And that deals with sections 1 to 4 in terms of the lis pendens itself. And also it's in sections 10 to 13, which deal with the recordings that deal with a foreclosure. Again, foreclosure has to be recorded, and has to be, the change is to make sure it's recorded in every county where the property is located. The second proposal is in section 5 and 14. And what this does is, what happened is this statute amends NRS 40.255, and 40.255 is in the section of NRS dealing with legal proceedings with evictions primarily. And what happened when the law was amended in 2019, a number of sections in 40.255, which really dealt with the relationship between landlord and tenant rather than any proceeding, were put in this statute. So our proposal is simply to move these provisions out of the chapter dealing with proceedings and put them in chapter 118A, which deals with the Residential Landlord-Tenant Act, which deals with the relationship. Our third proposal is deals with NRS 40.504, and these statutes, NRS 501 and a number in this area, deal with what happens if property owned by a lender, or that is mortgaged to a lender, is contaminated environmentally. And the definition of hazardous condition includes a reference to the 1988 fire code. There is no such document anymore. It's been amended several times. The proposal is to remove that reference. The fourth proposal, NRS, this deals with, in section 7, NRS 106.220. This statute requires that documents relating to subordination of a lien must be recorded. And there's a reference to any interest in property as well as a lien. And as some of you may know, many leases contain a provision where the tenant agrees that the lease would be subordinate to the landlord's mortgage under certain conditions. And the way the statute presently reads, and actually we tried to fix this in 2021 and didn't quite do it all the right way. It could be interpreted to refer to that you'd have to record any lease that had a subordination provision. And we think, going back and reading the legislative history of the statute, it's really intended to only deal with mortgages. So we clarify that language. Our fifth proposal deals with the definitions in NRS Chapter 107. And this originally was a proposal from our real property section. And I guess I should make it clear, and I did in the memo, that I'm speaking for the members of the executive committee and not the section itself, not the members of the section, not the state bar, just the members of our executive committee, which is a 15-member group of lawyers who practice real estate and throughout the state. But in 2019, I think it was, we gathered there were a number of definitions in NRS 107 that are used in more than one statute. And our proposal was, let's put these all, there's a general definition section in NRS 107.015. Let's put all the definitions in one section where you can find them, and you don't have to, hunt around the chapter for where they're defined. And I think what happened was that there's a reference to surety and surety company which was in NRS 107079, which deals with a statement from a beneficiary. And the definitions were moved out of that section into the general definition section. But the word surety is also used in another section. The definition that's in the definition section refers to a surety bond. But there's another statute, NRS 107095, that refers to a surety that really is just referring to somebody who is like a guarantor of a mortgage loan. So we wanted to take the definition out of the general section and put it back into the specific section so that it's not confusing. There aren't conflicting meanings of that statute, of that term. And then I think the last proposal, number 6, deals with NRS 645-8801. In Chapter 645, which deals with regulation of brokers, real estate brokers, a real estate broker can make a claim for commission against escrow proceeds. And the escrow agent then has to do something about that that claim upon the escrow proceeds. And this deals with commercial real estate only. One of the things an escrow agent can do is put the money into court. And what we want to make clear is that and the statute actually says once the escrow agent puts the money in court, the escrow agent is relieved of its liability. We're just closing the circle here, where once the escrow agent has deposited the money in court, the broker needs to withdraw its claim against the escrow agent. So those are our proposals. I'd be happy to answer any questions or give further explanation or point out the specific language, whatever the chair or the member senator would like.
And Madam Chair, that'll conclude our presentation. We'll be open for questions.
All right, members of the committee, do you have any questions? Senator Stone, go ahead.
Thank you, Madam Chair, and thank you for the presentation. On point number 6, when you talk about the agent that refers the commission demand to a court rather than a escrow agent, can you give me an example of that, please?
Well, I think first of all, the statute.
Mr. Buckley, if you could say your name for the record.
Michael Buckley, once again, real property section. The statutes are designed, first of all, to make clear that the broker does not have a claim on the real estate, but the broker has a claim on the seller's escrow proceeds. So what would happen if the seller and the broker got into a dispute where the seller refused to pay the broker the agreed upon commission, or there's a dispute about the commission, the broker is entitled by statute to deliver a notice to the escrow agent and say, we have a claim against these, and it's, you're subject to our claim for commission. So you can't disperse these proceeds to the seller unless we resolve our claim. And the escrow agent, they can either try and resolve that claim, or else they can just say, we really don't know who's right or who's wrong here. We'll just put the money into court and let you, the broker and the seller, figure it out in court. And at that point, the escrow agent's out of the argument. It's kind of a common thing in escrow.
Okay, so basically it's a dispute between the broker and the seller as to the claim to a commission. Obviously, escrow agent doesn't want to get in the middle of a legal debacle for which he doesn't have he have the skills to adjudicate. So you just send it to the court and let the courts deal with it, right?
Michael Buckley, yes, that's correct.
All right, any other questions from members of the committee? I'm not seeing any, so I think that will take us to
Chair
oh,
Scheibel,
go ahead.
apologies. Mackenzie Warren Kay, on behalf of the real property section. Mr. Buckley, if you could please address section 15. I think we may have skipped over that in the presentation. I just wanted to make sure that was clear for the record.
Section 15 is really just part of what where we move the language out of chapter 40 and put it into the residential landlord tenant act chapter without any substantive change. We just took it out of one chapter and put it into another. So that's section 15. Oh, excuse me. There's one more change. Thank you, Mackenzie. Michael Buckley again. In the Residential Landlord Tenant Act in NRS 118A, which details a number of requirements that a lease has to have and their procedures and dealings with a lease of a residential property. There's an exemption if the tenant is the buyer of the property. What we've added here is that it makes more sense that if the tenant is the seller who stays in possession, that there is an exemption for that relationship, because actually the seller knows more about the property than the new buyer, the new landlord. So we've just added that too, and it's an exemption for 90 days after the seller buys the property.
All right, thank you so much for those clarifications. And I think unless that raised any additional questions from the committee, we will move on to testimony. We will start with testimony in support of SB 223. Anybody wishing to give testimony is invited to the table here in Carson City, but I'm not seeing anybody, so we will go directly to the phone since we do not have our connection with Grant Sawyer today. So phone testimony in support of SB 223.
Thank you, Chair. The phone lines are open and working. However, there are no callers to offer support testimony at this time.
All right, then we will go to testimony in opposition to SB 223. I'm not seeing anybody come to the table in Carson City, so we will once again go to the phone lines for our testimony in opposition to SB 223.
Thank you, Chair. There are currently no callers to offer opposition testimony at this time.
Okay, then we'll try one more time with testimony in the neutral position on SB 223. I don't see anybody coming to the table in Carson City, so we'll go to the phones.
Thank you, Chair. There are no callers to offer neutral testimony at this time.
All right, thank you so much. Then that brings us to the conclusion of the bill hearing on SB 223. I will now close the hearing and move on to the last item on our agenda, which is public comment. Anybody wishing to give public comment is invited to the table here in Carson City, but I don't see anybody. So we'll go to the phone lines for public comment.
Thank you, Chair. The public lines are open and working. However, there are no callers to offer public comment at this time.
All right, then that brings us to the conclusion of our meeting. We will be meeting again tomorrow at 1 p.m. And until then, we are adjourned.